May I, Your Lordship? Your Lordship, I beg to mention item number 21 on behalf of Standing Counsel of NHPC, Mr. P.K. Tiwari, sir.
21.
21, yes, Your Lordship. On behalf of P.K. Tiwari. This matter may be fixed on Monday, and we have already taken consent from the other party, Your Lordship.
Monday we have enough matters fixed. You're making this prayer on behalf of
P.K. Tiwari, sir.
P.K. Tiwari.
Yes, Your Lordship.
On a prayer made on behalf of Mr. P.K. Tiwari, Learned Senior Counsel, and not objected to by the Learned Counsel for the petitioners. Raised to list this matter again after 2 weeks on a date to be fixed by it.
Your Lordship, on Monday.
Monday we have fixed up a lot of matters.
He is arriving from
Can't help it.
Guwahati on Monday.
Can't help it. Because we have fixed up a lot of matters. That's the problem.
It might clash with his other
Can't help
matters
it.
as well. All right, Your Lordship. Deeply obliged.
I beg to mention this one on this matter, a criminal petition
Madam, before
805.
the senior court. Before the senior bench.
May I please, my lord? I beg to mention item number 8. I am for the respondent number 6. I've taken consent from the petitioner counsel. Can it be posted on Wednesday?
Excellent, excellent.
Here, the conducting counsel is Mr. Tony Burton. He'll be available on Wednesday, my lord.
Just hold on. We had asked for some records. We'll see whether the records.
My lord.
Lordship, I'd like to mention item number 3. The leading counsel is out of town. Lordship.
No adjournment. You have not made a mention yesterday. Be here.
Okay. Lordship, I'd like to mention item number 13. In this case, we need some more time to file an affidavit.
Let it reach. No adjournment at 10:30.
Hello, please.
May I please, Your Lordship? Lordship, I beg to mention item number 24. Lordship, the party herein has already settled out of the court. Therefore, I beg for the withdrawal of this case. I am for the petitioner, Lordship.
Your name?
L. Teni.
You're not here. You're not in the case.
It has to be, I should have it.
L. Tezing.
L. Teni. Teni. T-E-N-I.
Item number 24. Rigoriba.
Yes, Rigoriba.
Not there. Your name is not
Yes,
there.
Lordship, it is not in the cause list, but in Bakalatnama.
Heard Mr. So-and-so Learned Counsel for the petitioner who submits that the issue involved herein has been settled out of court by and between the parties. So accordingly, there being no live issue. Arising in the present proceedings for consideration by this court, the writ petition stands dismissed as having become infructuous.
Highly obliged.
Yes, madam.
Your Lordship, I beg to mention item number 22. Item number 22. Here we have to file rejoinder, but we
Call it. Call it. You have filed rejoinder.
no, we haven't filed till now.
Then when it reaches. When it reaches.
Much of that.
Lordship. Lordship, I beg to mention item number 19 and 20, Lordship. Mr. Tijamo, leading counsel, is out of station, Lordship. So this matter may be listed after.
What does matter? We'll see when it comes.
Okay.
I beg to mention item number 13. So, we need to file our affidavit. So, need some time.
Item number 13.
Yes, my lord.
Already I mentioned rejected. Let it reach. Yes.
My lord. May I mention item number 6, my lord?
For jury.
My
You
lord.
are for?
I'm for the petitioner, my lord.
Okay, yes.
Next week, my lord.
No. Today itself, what is there?
We have,
You establish your case, we'll see, because they have filed an affidavit, they have brought on record materials.
we have misplaced the file next Monday,
Right,
Monday.
Second file, they do.
My lord.
You take the first file also, no problem. Just satisfy me what is left there. That's
My
all.
lord.
You have made big claims, but now everything has been after the affidavits, nothing is there. Hmm.
My lord, I am not there here, my lord.
Whoever,
Actually, Mr. Jejini is there, my lord.
whoever,
Yes, sir.
matter will come, we will take up.
My lord.
I told you yesterday, if you don't make a mention or give me a mention memo the earlier day or a adjournment slip, I'm not going to adjourn.
My
Or I'll change my habit. I'll not read any brief and I'll come.
my-
You all then explain. I'll do 3 matters daily and go. What is there for me?
Yes, sir.
Right? Let it reach.
My lord.
Tell it.
Matter.
Who is appearing for the respondents?
Respondents, it's a Mato Kato, he's not there.
He is not here. Somebody will be here. Yes, what is your case?
Because, in top is office town. He informed me by this morning, taken measurement.
You did inform me yesterday.
Supposed to be come by this morning.
This practice we will have to give up, counsel. You will have to start. Yes, what is your case?
Yes, my lord. My lord, what happened here, my lord?
Now tell me one thing.
Yes, my lord.
After the orders of this court,
Yes, my lord.
judgment at page 33 was passed,
Yes.
right?
Yes.
What happened thereafter?
Thereafter, my lord, the authority has to file another order, my lord,
12, under section 12.
under section 12.
They have not passed that order.
Not fast. So,
Get your instruction. We'll have it on Monday. As to the, after the passing of the order at page 33, what steps have been taken by the authorities? Heard the learned counsel for the petitioner. On the next date of listing, the learned counsel for the respondents shall apprise this court as to the steps taken in the matter by the respondent authorities in pursuance to the passing of the order in case number 2/90 under section 10 bracketed M of the CRPF Act 1949. Order is dated in pursuance of the judgment and order dated 30/5/2017, passed in case number 2/90 under section 10 bracketed M of the CRPF Act 1949. Tuesday query. Yes. Retrospective effect. Satisfy. 2017.
Mike.
Yes.
Was my case covered under Mayum Karga case, Your Honor. 2004 Supply JLT 65.
Totally distinguishable. There was an ad hoc promotion. Subsequently, the regularization took place through the regular DPC.
Yes.
So it was given retrospective. Otherwise, you show me what is your case.
Your Honor, as my case in 2014 itself,
Vacancies were there.
vacancy was there.
They had not. filled up the vacancies.
We were eligible during
That time, the law is, in case of promotion,
and
it will be as per the rules, and the rules does not contemplate any retrospective effect, right?
it is the fault of the department.
Can't help
They
it.
have not conducted.
Will Mr. Navam accept that fault? He has given some reasons also. He will not accept. Will he concede? He will not, because that will be against law. Anything more?
Lordship, I will then live up to the wisdom of the.
No. Then it's dismissed.
Yes.
I'll pass the order in the second. दो बजे की तरफ के साथ इसमें. There are decisions of the Supreme Court. I'll quote it.
Your Lordship, you can just have a look and that judgment passed by Justice S.K. Kaur in Ramjit Singh Kaur, Poonam case.
Poonam.
Yes.
Poonam,
Poonam case.
in the facts of this case, may be a
Slight
slight difference. That's why
But-
we'll go with the earlier one. We'll
Earlier
go with the,
But there
89.
also Supreme Court said, my lord, it must be.
but that is again in a slightly
Slightly
different
different.
context.
But-
And the other judgments, 1989 onwards,
Yes.
there are judgments which says that you cannot have a claim from the date the vacancy arises.
Vacancy.
And it was reiterated till around 2017 also.
I was just only referring to that selection.
Mega Chandra is in terms of that, what do you call that, Pamar.
In Manpreet, it was said, further said, Malak, selection process, then recruitment rule must provide.
Must,
That's most important.
the underlying factor is that if there is a procedure prescribed, the day the procedure is done and the orders are issued,
Yes,
from that day.
absolutely.
Sorry. Next time,
Alright.
better case. Yes. Yes, counsel.
Lordship, the leading counsel is out of town.
You are the leading counsel. Argue.
So my name is located in the process. but-
Ah, that's why I said you are the leading counsel now. What happened to the advertisement?
That part I need to take in.
You have not even dealt with that in the affidavit.
That's correct, Lord. At that point of time.
That will be required.
Then I will.
And the council, you have made respondent number 4 and 5 parties,
Yes, Lordship.
but you have not prayed for any relief.
Yes, Lordship.
That is why Mr. Tara is very intelligent. He has not even filed an affidavit here.
That's why in the earlier.
There is a
days-
Hindi saying, na aap bail mujhe mar. So he is safe. He has not even filed. Why have you made them parties? The best thing I can do for you is, I can ask you to make a representation and ask them to consider it under the scheme, if any, available for regularization. They will do it in that manner. And dispose of this. Why keep this matter pending from 2018? What is happening? Nothing. You are not benefited.
Yes, sir.
Then other things, what you have said, are all only Mr. Pratap, get an instruction, what happened to this recruitment process. We'll have it at 2 today. Just a phone call. I only want a word from you. I don't want anything written.
Okay, I'll.
2 o'clock.
Well, for disposal.
As you say.
No, my lord, my lord might already have parents the synopsis and the grounds that I have raised. Now, my lord,
Yes, Mr. Modi, we'll take it up for decision.
now, my lord, kindly come straight,
Give me a facts first.
Yeah. my lord, it is since,
Who are you?
I am the secretary of the practitioners. And then, my lord, 1974 onwards, I was in occupation of the land. And there was some disputes. In 2005, there was a kaba. And in the kaba, it was in my favor. And thereafter, my lord, that is by Kaba, that is, my lord, just I am giving the facts, my lord. Then on 13/4/2005, the issue involved was amicably settled. That my lord will kindly peruse from page 41 to 46. Then against that,
Page 42 is the translated copy.
yes, page 42 is the first. This is the decision. Now, since that, the applicant was in possession of the land. And now, we'll only kindly appreciate one principle of law, that is the law of adverse possession.
Law?
Adverse possession. So this possession is in my favor. There's no dispute.
I had heard this matter.
Yes. So I am coming to the point, after a few moments from now, the exact question of law. Now the Kaba decision that my lord has seen at page 47 to 53. In this case, what had happened? There was a gentleman called Bakan Partin.
Buckham Party.
Bakan Partin. Bakan Partin. Now these gentlemen says that although I have participated in the Kaba, the minutes that were drawn, I have put into my signature. But later on, he started disputing that and he started withdrawing that. Now thereafter again, now the problem will start from here. The question of law will start from page 54 onwards. The type copy is at page 56, the translated version. Today on 13 September 2016, a Bango Kawang was conducted by Mebo Bango and Mongo Bango Kawang on the complaint made by Bakin Protein. Bankin Partin, stating that Sri Kukuluk Partin has wrongly demarcated the boundary in the presence of two Bango's members present along with elderly public leaders and Gamburas were heard. And after hearing from both the parties, the Kaba passed the following decisions. The first point is the land purchased from Sri Okit Rome and late Pajin Perme by Sri Banking Partin shall return back to Sri Banking Partin. Two, Milord, is important. Sri Banking Partin in the Kaba mutual settlement in respect to the boundary demarcation has misunderstood and put his signature, and same has been withdrawn lately. And the word lately. Hence, for such late withdrawal of the signature by Banking Partin 2,500 rupees is imposed as a cost. The previous decision of so and so 2005 Kaba letter has been declared to be reasonless. Now, my lord, the
Reasonless.
Now the question comes: is there a forum called Bango label exist under the AFR? Under the AFR, the answer is no, my lord. My lord, how it had happened is under the AFR 1945, Section 5 provides
Now tell
for
me
the
one thing, that
Yeah.
the original Kabang
yes
was held in a village level,
in a village.
page 42.
Yes, and
So
it was
page
decided in
56,
2000 after 11 years. My lord, kindly see.
26, 27, 3, 1974,
Correct.
and 13/4/2005 and 24/8/2016.
Correct.
So the others who have signed,
They have not disputed.
they have not disputed.
They have not disputed. So therefore, my lord, that adverse process and
So is there any interim order here?
yes,
Where is the interim order?
impugn order. My lord.
The interim order?
Interim order.
Nothing.
No, I think personal. My lord, that I cannot assist. It must be in the note, my lord, office note.
Was there any interim prayer here?
Prayer was there. Coming to that. Yes, my lord.
Okay.
Page.
And the office order, take me to the office order also.
Yes.
So page 56 is the starting point.
A starting point. Then the question comes whether a forum called Bango level Kebang exists or
Bango Kebang.
Bango Kebang under AFR 1945. The answer is big no, my lord. Now, that's such, my lord, there is a Bango level Kebang recognized after the amendment of AFR coming into force of the Civil Code Act 2023. But that in the volume 1 of that act, section 24 speaks, I think section 24, right?
No, we'll come to that. We just get me to the facts.
Yes, sir.
Bango Kebang, then what happened?
Then,
You took up this matter?
yes,
You went up at page 62 to the
yeah,
additional
page-
deputy commissioner.
page 62. Then against it, I have filed the representation.
Hmm.
62, my lord, for a moment.
That here you have not said that that is without jurisdiction.
Yes, without jurisdiction. From here, I have started, my lord.
Where is that?
Page 62, my lord.
Huh?
G.
Jurisdiction point?
Let's see, no, my lord, here, I think we have not raised.
Then what happened?
Make this appeal Bango decision that the motion party. Here, my lord, the question first we raised was that we were not part of this Bango decision, my lord. We were not party.
Now, how come this Bango decision? Because it also takes away the demarcation made,
Yes,
reasonless.
reasonless, and you do not have the power under the AFR because a forum is non-existent and is not recognized by the law. Without authority of law, you cannot decide this. So therefore, it is authorized to the law, and this is not even.
Okay, come to page 64, the additional deputy commissioner's
Yes.
order.
Now, my lord,
He again refers back the matter to Bango Kebang.
correct.
Bango Kebang.
Therefore, the deputy commissioner or the additional deputy commissioner, my lord, in terms of that definition clause, my lord.
We'll come to that.
Yes.
Then what
So-
happened?
Then he
There was a
referred the
fresh
matter
decision.
back. Yes, my lord. Then this cover took
Hmm.
place then 68, my lord.
You call this Kebang.
Yes. The decision is, my lord, two is important, my lord, in my case. On Kebang dated 13 April 2005, banking party himself agreed with the said Kebang decision, mutual settlement by putting signature and withdrawing of his own signature on that 15/2011 is an illegal act. Hence, withdrawing of signature by Sri banking party is not considered and rejected by the members present in the camp. That was the decision. Now, the original land is restored in my favor.
Now come to 3,
Free, my lord.
page 68, clause 3, decision.
Decision, my lord.
Hmm.
Today's decision passed.
No, clause 3,
Cross
the land purchased by.
Purchased by Bakin party, which was decided that it will remain with him as per Kawang decision 24 August 2016, wherein this Kawang called by Baptist Church involving two bangos has been decided as per the Kawang.
What is the meaning of this?
That means one of the demarcation, the land demarcation that has taken place in 2005, where this banking party has some portion of the land, it will remain with him.
That will not come to you.
That will not come to. And Ballot 5 is very important here.
Hmm.
It appears to be a binding consent decision, consent by both the party leading to a decision. Today's decision passed today, and by both the bangos shall not be altered by any
both
other-
Bango Kebang means the earlier one also.
earlier one also. In future, the sketch made drawn on 30 April 2005 shall be the same.
Okay, then what happened?
Now the matter came to an end here.
So if it was a mutual decision,
Then
then why did you go with page 74?
It is not by me, it is by Mr. Parthin, who is the respondent number 4 here.
This is 74 is by Patil.
Yes.
Then what happened?
Then thereafter, the order was issued at page 78, Annexure K. This 26th December. Regardless, summon Kebang notice. So and so they did about the 6th December 2016 in the instant case. It is to inform both the parties, GVs, land sellers and witness that the Kebang fix on 10/1/2017 has been deferred to 18/1/2017. The Motum Church, Abu have submitted a petition to this office
The
that
first Kebang was called for.
yes,
Who called this? By the additional deputy. commissioner.
additional deputy commissioner. My lord will mark this, whether he has a power to direct this after Registrar General judgment. Can you please help us? 2013, 4 GLP, page 1109, paragraph 13 to 15.
Okay, then what happened?
Yeah. Then, my lord, then what happened is, then these representations was submitted by the Baptist Church, the Motum Baptist Church, at page 79, against the Skava decision.
Hmm.
We're saying that you don't have the jurisdictions. My lord.
Hmm.
Now, my lord, then what happens is page 94, two of the Gangburas, my lord, they are part of the Baptist Church. So they,
Res judicata.
yes, res judicata comes, adverse possession comes. Now, my lord, the larger question is,
No, then what happened? This
then
is
what
the-
happened? Then, my lord, there is a kava again. That translated copy page 100, my lord. Three decisions were taken that day, my lord. First of all, this Bango Kawang, Sri Okit Rome, by showing his own hand and by stating that with this hand I have cut and cleared the jungles of the land, and if any ordeal is to be performed, I am ready, for which the Kawang decided in favor of Sri Banking Party. Two, if the second Bango Kawang, Sri Gongo Rome, son of Sri Okit Rome, stated that my father is.
So they dispute again.
They again dispute again. We have wrongly signed. Again. Now, that constructive residue.
This is also Bango Kavin?
Bango cover.
Then what happened?
Estoppel is also there. Then thereafter, I think, that is the end of the matter. End of it. Then, then there was one reply. Then the Bakian party again files this representation letter to the additional deputy commissioner.
Page 113 is the order.
Yeah. Yes, ma'am. On perusal of the records and the petition submitted by the parties and also statement of the parties on hearing GBs of Martin Village, namely so and so, so and so, so and so, were not attended the Bango held on 18/1/2017. The Bango Kamasri Bankeng 14 versus Abu Baptist Church Motum held on 18/01/2017 was conducted in connection with the disputed land which falls within the jurisdiction of Motum Village. The attendance of GVs of Motum and owners, witness and call of DL are must in such Keba. Therefore, in view of above, the instant case is hereby sent back to GVs of Motum for hearing by fixing a date convenient to party and for all to attend the Kava and to amicable solution. However, it is revealed from the paper furnished and statement of parties that out of three GVs of Motum Village, namely so and so, so and so, are a member of Abu Baptist Church of Motum Village, which is part of the parties, not neutral body in this particular case. So, chairman of this case should be selected a neutral GB. Both the parties should maintain the status quo.
Now
Yes.
just come to your prayer.
Yes. page 34. Well, that every to the
Just
next,
give me the page numbers of these orders. 22-8,
Ma'am.
2000.
well, these orders, annexure team, my lord, will find at page 116.
Hmm.
6.
S.
S115, my lord.
Hmm.
Q113,
Hmm.
A78, H64, my lord. And the next prayer, my lord.
Just a-
Yes, 2005. 2005 order as a 10 permanent. Bango, there is no Bango. There's no appeal.
And these orders, subsequent orders, are all on the basis of appellants filed by respondent number 4.
Well, that annexure N,
Hmm.
in the prayer number 2, Malad.
Hmm.
Annexure N, page number 97 to 108. Prayer number 2. Annexure N,
97 to 108.
I 65 to 73.
Right.
E, Malad. E,
This is the Kabang of 18-1.
yes, yes. E, Malad, is 54 to 60.
I,
Malad, 65 to 73.
and
E, 54 to 60.
54 to 60.
Yes.
Okay.
Now, Malad, the short question is,
Now, what are these 22-8? Dates of this? Same thing.
same, this is same. The interference is called for, Malad. Now, after 2005, Malad, the first, Malad, we kindly,
Look,
that page 41 to 42 is important, Malad, that
40,
13/4/2005.
42,
Yes, Malad.
42.
Yes, sir, page 42, 13/4/2005 decisions between the parties. Now, that is the key point in this case, Malad. Now settled, boundary demarcated, and the possession of the lands were handed
Now, what
over
is
to
the
parties.
situation in the field?
I am occupying still.
You are occupying?
Yes.
Yes.
It's in my possession.
What is your decisions you want to relate?
Now,
Section?
simple question of law I am placing it. Now, after this 2005 decision, village level decisions, no appeal was preferred either before the assistant commissioner or the deputy commissioner.
They directly
the
went to
old-
the Bango Kabang.
They went to the Bango Cup. Now, therefore, this has attained finality. So therefore, the res judicata comes. And in fact, my lord, the constructive res judicata
Okay,
and it's
fine.
proper.
Tell me why you say that Bango Kabang is not maintainable?
Bango Kaba decision. Under section 5 of the, yes. The first the answer is, kindly have this old one, old book, old book, the volume 1. You have new also, kindly give new also. I'll
Page?
page 65, Lord, section 40. Then 46. And then 46. The village authorities shall try all suits without limit of value in which both the parties are indigenous to the Union Territory of Arunachal Pradesh and live within their jurisdiction, which are not submitted to arbitration under the provisions of section 38, or other suits which are not submitted to the arbitration under the provision of section 39 shall be tried by deputy commissioner or an assistant commissioner.
So it's here the village authority.
Village authority. Now,
Is it defined?
decision against the village authority has to be preferred either before the assistant commissioner or the deputy commissioner. Now, my
Village
lord,
authority is not defined anywhere in this act. Is it defined?
Village authority, it is defined, where the definition clause is defined. Huh. Anyway, it's made. 1945 definitions.
Only section 5.
Section 5. So now, my lord, kindly section 46. My lord, on the teeth of section 40, if anybody is agreed by the decision of the village authority, the forum is prescribed at section 46, page 66. My lord. 1. Any person agreed by the decision of a village authority may appeal to the assistant commissioner in suits not exceeding 500 in value and to deputy commissioner in suit exceeding that. Now here the private respondent has not resorted to the remedy provided to him under law or the statute. Now, my lord, that section 5, my lord, have already seen that only the village authority and no Bango level kava is decided. No, is in existence. Now, my lord will kindly, now I'll place that. Now, my lord.
This was amended.
Yes. My lord, kindly that amended provision, page 56, section 24. New one.
I got it.
My lord.
I got it.
Yes.
Yeah.
Now, my lord, then what will happen?
Village authority,
Now,
any
section-
party
Yeah.
aggrieved by a decision of the village authority may appeal within 30 days before the inter-village territorial customary court or apex customary court by whatever name called, who on receipt of the same shall dispose of the case. Provided the okay.
Now, therefore, my lord, kindly
This
come,
amendment came into effect from
my lord, 2023. In the
no,
bottom,
it was given retrospective effect, 22/1987.
but it has come into force.
Be that as
from-
it may, by application of law,
Huh.
legal fiction, it's there from 22/1987. Then
That is law cannot be retrospective, my lord.
but that you have not
No.
challenged this. This is given retrospective.
My lord, still, that amended, kindly see the amendment.
It shall deem to have come into force with effect from 22/1987. Then
Now, in that case, my lord, immediately the Reassessment General Judgment is overruled by this. You cannot do that. Legislature, with the greatest respect, my lord, cannot directly repeal. Direct override the decision of the court, my lord, unless or otherwise.
no, that we can always consider in a different context. But insofar as your question is that this is not a prescribed forum,
That I have
that
seen.
goes.
That is.
That goes.
Now, my lord, there are two decisions of this court, which says Bango level forum is not a forum recognized under law. Now that law operates. Then in that even, which one will prevail now? Well, that kindly help.
Now tell me, what is this Bango?
Bango, my lord, basically, my lord, let me explain in nutshell, my lord. In Nisi, we call it Niel. We do not have this interplace council system. The Mompa, they call as Sorgan. Sorgan or the Sorgan.
Bango is of?
Bango, basically, this AFR basically is only made applicable in most of the cases, only in case of the Galo and the Adi tribe.
So Bango is related to Galo and Adi tribes.
Adi, man. It is nothing to do with other tribes because we have our own set. This point was never been argued or submitted before this court because it was not the sense that that point of time.
Because there was, the earlier people knew about the law. I don't know about the law. That is why the submissions are coming.
Correct. So therefore, now, my lord, what will happen? In this one of the case, my lord, that my brother Pangin is missing today, we argued. There are 7 and 8, my lord. Both of us had a good exchange of view. Now, Lord, now then,
So this is prior to the amendment.
prior to that. That was the appeal, my lord. Kindly come, my lord, the same set of facts, nothing as such, my lord. Para 7. Under Assam Frontier Administration.
got it.
Now, my lord, what had happened is in 2011, my lord, CRP number 27, 2011, that is Ige Tacha versus Ikardirchi, where I was also part of that. Then Lordship Jamir has rendered that under section 5 of the AFR, Bango Label Forum is a
This
non-existent.
is before 2023 or after 2000?
Before 2011. So therefore, these two laws are there, my lord, well settled, my lord. Now, therefore, if it is to be given retrospective effect, all the decisions rendered from 1987 till that.
It's a known process.
Non-process.
Well, what has happened has happened.
What has happened has happened. You
But
cannot correct.
today now whether I can ignore the amendment, retrospective amendment and the legal fiction coming into play.
Correct. There is a conflict because my lord is well aware. Laws are always laid down by the two forums in this country. Judiciary, the Constitutional Court, and the legislature, my lord. Now, there is a judgment as well, my lord. Just I forgot to bring it, my lord, because I did not anticipate this question to fall from my law. Now, what happens? Law is well settled, even by a stretch of imagination, in exercise of their domain of power, enumerated under Article 246, 7th Schedule, entry 1, 2, and 3, list 1, 2, and 3. The executives are not executive either, even the parliament are not empowered to directly overturn the decision of the judiciary.
They don't overturn, they just remove the basis.
They can.
That basis always can be removed.
Basis, yes. But here is a case, my lord, it is directly, unless or until, my lord, it is not put into challenge, it has a force of law. Now the balance of conveniences between the domain of executive and the legislature is to be, executive legislature and the judiciary, my lord, has to take a call on this.
Not go that far in this matter.
I know, my
We'll
lord,
try
that,
to find a middle way.
yes.
Yes.
I am recalling that A.K. Roy judgment. That is the best judgment ever that I came across.
Yes, Mr. Modi. Mr. Modi, one submission. He submits that the possession is still in his. Have you taken over possession of the land in terms of the Bango Kaban?
My lord, the particular portion which I have purchased is in my possession, my lord. So this is also my
What
lord,
is
the
the
wrong-
total area of land that you have occupied or which was
My lord,
in the, in
16,000 square meter.
no, just no,
16,000 square.
in terms of the first decision
Yes.
of the Kabang,
Yes, yes.
what is the land that has been given to you?
16,000 square meter. That I read that somewhere.
And what is the area of land you claim?
My lord, just my lord, I'm frankly, honestly, my lord, I'm admitted that that has not been explained. In the numbers of the meeting has took place, but description
Okay.
has already been explained, but no particular how much of the area that was
So
not
there
explained.
is, you claim you have, your land was also given.
Yes.
initially To the church. And you signed in the Kabang decision.
Kebang decision. And
Subsequently-
subsequently, when I come to know that the particular portion which I have already purchased, that resident for myself is also included in
Because
this
see, the
charge.
problem here is the decisions are there, but the description of the land is nowhere.
Madam. That matter, clearly I admit, honestly,
Modi, we know
because
that's why
nowhere.
We
On-
only expect that conduct from Mr. Modi. That's why we openly asked him. I know that reply would be that.
No, my lord.
You will not twist. I know that.
No, 15, page 15, please come.
50.
15. I read somewhere, so. 1.15, the descriptions of the land is there. That in the meantime, the original owners of the land, namely, since this is late Okit Rome, Sri Goram Apam Sri Yamuk Megu, the mortem of the church, along with the land purchase and that is present.
Okay. So, Mr. Modi, do one thing. Even if we direct that your part should be given to you, there will be a dispute. What is your part? Right?
Well,
Go before the civil court. Exercise your right there. We will direct.
my lord, let me place my place. Now, my lord, for the argument point of view, first of all, my lord, what I can see from the submission of the brother.
No, I accept
that. My lord,
I am ignoring the submissions of Mr. Tara to the extent that Bagong Kebang is not maintainable. I say it's maintainable.
first of all, my submission would be, wrong picture has been beautifully painted before the Lordship that my brother has tried. This is the case, my lord. First of all, my lord, one point, my lord, since my lord has assumed that all the representations submitted before the deputy commissioner, additional deputy commissioner Mebo was, my lord, not me, my lord. I am for the respondent number 4. But that all, my lord, submission was made by the petitioners. Now, I understand that there are the petitioners who submitted before the deputy commissioner or the additional deputy commissioner to say that who have filed against the order passed by the KEBA. Now, the reaction of the deputy commissioner is that yes, you decide the matter before the village authority. Here the village authority said that since we have already decided the matter,
No.
the matter has been decided in the Bango level.
There is a touch there. First, there is a decision, 1-2 decisions of the village authority.
Mal.
You are aggrieved.
Aggrieved, Malo, this.
You go before the Bango Kabang.
Malo, that.
Bango Kabang renders a decision. Against that, he goes before the additional deputy commissioner. Additional deputy commissioner remands him back to the Bango Kabang.
Bango.
There is a further decision. Again, that is vague, nothing. Against this, he again goes. Now the village authority says, we are not deciding, we have already decided. That means the first decision of the village authority stands, wherein you have signed.
That part, my lord, I admit.
If
Now-
that is admitted, what is left, Mr. Modi?
My lord, what is left in this present cases? My lord, if the present case, if the present.
Now you
case-
establish your
My lord,
case. Forget Mr. Tara. I'm not even concerned with him now. You establish your case. What is the land which you claim out of the 1,86,624 square foot given to the church?
My lord, that I have already submitted that no specific mention was there except the boundary, my lord.
Mr. Tara,
My lord.
why don't you give him back his portion of the land?
No, for that I need instructions because I am also engaged at later point of time in this. case.
Give him his land if he is not wanting. You're a church. You should be benevolent more. Give him back. Why should a soul have this trouble?
My lord, I am handicapped as of moment.
Go.
Now, my lord, that this.
Go. You take back the land. If he gives it. Otherwise, we'll find out a way.
At 2.
2. Done. Why the small things you should blow it out of proportion? Just that thing, or Mr. Modi, you give me the land, exact land of yours. And if you can't give me that, if Mr. Tara says no, then you will have to go before the civil court. Or the division bench, whichever is more feasible.
No, my lord, CRP, Karol, SLP.
No, appeal from this order. For my order,
This is
appeal.
what?
This is writ petition.
WPC, okay. I thought it is a CRP because
2 o'clock.
2 o'clock.
Yes.
And I think you should mutually settle this.
I also think.
Number 5.
None to press the writ petition because that petitioner himself has taken away the brief. Right? You be there. Not this, I'll do that. Same, the earlier orders passed by this court in the present proceedings, which reflects that the petitioner had taken the brief from the counsels engaged in the present proceedings. So, when the matter is called up today, when the matter is called up today, none has appeared on behalf of the petitioners. Also, there being none present on behalf of the petitioners to press the present proceeding, the writ petition stands dismissed for non-prosecution. Yes, perjury, show me.
My lord, yeah, my lord. This matter may pass over for a moment at 2, my lord.
Okay.
The leading counsel is coming.
Okay. And you also be that pages where you have given that appeal.
Yes.
The records are here, madam. The records,
Lordship, on last occasion, the original
records were produced and therein that appeal was there.
appeal was there.
But there was no endorsement on it that it was given to somebody.
Lordship, the
hearing.
endorsements also, they only that they disputed is that
Date.
they with only the date that
Date.
our own copy we have marked it as 26, but it is on the 23. That's
Right.
all. Nothing more than.
My lord.
Item number 7.
Yes, Mr. Modi.
Also for pleading is concerned, I'm waiting for the reply from respondent number 5. Otherwise, 2, 3, and 4 has already filed.
5, if he is not interested, let us forget that.
May I please, Your Worship, the main conducting counsel is absent today, Your Worship. Miss Aji Ite, she is the conducting counsel here, Your Worship, she is absent today. Your Worship.
On the prayer of the learned counsel for the parties, list this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Item number 8.
May I please, my lord?
Hmm.
Earlier this morning, I prayed for adjournment, my lord. As the leading counsel, Mr. Pertin. I am for respondent number 6. Private respondent.
How can a judicial magistrate go and decide a title? You are there in the case.
My lord, but I have very little knowledge, my lord.
Why? Patin is not giving you the briefs.
My
Is he taking it along with him?
Not, that is not
Hmm?
the case, man. I don't want to plead with my lord, little knowledge, man.
Now, madam, you were supposed to place on record the records wherein this decision was taken.
Yes, Your Lordship. Here, we have communicated to the department, Your Lordship. We have not
Records have
received.
not come.
Yes, Your Lordship.
As prayed for by the learned counsel for the parties, raised it to list this matter after 4 weeks on a date to be fixed by.
Highly obliged. My lord, this is a settled matter, my lord.
Here, my lord, our affidavit is ready, man. I need one week time, man, to file.
You are paying for?
I'm for respondent 1, 3, and 4.
This writ appeal involves the same
Yes, my lord, the question was asked to the respondents, my lord.
Hmm. Where is your land here? Just a moment, madam. Okay,
In fact, Lordship, this matter has went to the Supreme Court, Lordship.
so come to Kapau. And in the writ appeal also same area.
Same, Lordship, same stress of road, Lordship.
Then,
Same.
madam, what do you say about this decision?
Yeah, my lord. Our affidavit is ready, my lord. Only 1 week time, my lord.
Lordship, in fact, the state, they have
This
went
is
to
in Anjav district.
Yes, my
Lordship,
lord.
went to the Supreme Court, Lordship. Supreme Court has not interfered, Lordship. And it's same mistake, the amount that was reduced after reassessment, Lordship.
Hmm.
That has been interfered with, Lordship. And then this is the circular, Lordship. Already, same mistake of broad disbursement has already been done, Lordship. The acquiring authority, Lordship, they have deposited the amount and already the amount are being paid, Lordship.
Okay, give me your details. What is your claim?
Lordship,
Give me the exact area of the land.
Lordship may kindly come to Annexure 5, Lordship, 5 series, page 39, Lordship.
Hmm. So this was the initial.
Initial assessment, Lordship.
Hmm.
Lordship will find the total amount at page 67, Lordship.
Hmm.
This is 4 crore 67 lakhs, Lordship, something
Hmm.
around that
Hmm.
figure, Lordship. Lordship may kindly come to page
This is
60.
exactly of 0 kilometer to 6.5.
6.5, Lordship.
Hmm. Okay, then
Page 68, Lordship, Lordship will
Joint-
get the clear picture, Lordship. This is the joint survey report, Lordship.
Hmm.
Down below, Lordship will see details valuation as per data collected from the field in department wise. Serial number 1 is the civil constructions, buildings, structures, etc. amounting to rupees 34 lakhs.
you are with the serial number 2.
I am with the serial number 2. Lordship.
Hmm.
Rest is as it is, Lordship. Serial number 2, they have reduced it.
From
Lordship,
this is 4 crores 67.
67 lakhs 72,467, Lordship.
Oh, that
They
is
have-
same here.
They have
This is
reduced
same.
2 crore, around approximately, Lordship, 2 crore, they have reduced it, Lordship. This,
No, this is as of 21. This is same as page 67.
yes, Lordship. It is as same as, just I want to figure it out,
Okay,
Lordship.
fine. Then what happened?
Then they have reassessed it as
That
at page
reassessment-
annexure 10 series, Lordship. Page 82, Lordship. Lordship will see the total figure at 107, page number 107, Lordship.
Hmm.
Lordship, page 67 and 107, Lordship. We will compare, Lordship. They have reduced it, half of it, Lordship. 4 crore, they have reduced it to 2 crores. In regards to, Lordship, this cardamom, fruiting and non-fruiting, Lordship.
So what does this court say in the writ petition? Similar issue was involved?
Lordship, similar issue was involved, Lordship.
Okay, come down. This is the Chaglam Rocham Road.
Lordship, same stretch of road, Lordship.
Name
Same-
is Chaglam Rocham.
Yes, Lord. Same stretch of road. Same stretch. Yes, we can same stretch. No? Chainage is different, Lordship, but the road is same, Lordship.
Had the government, central government deposited the earlier determined amount?
Lordship, in their case,
That was
amount
deposited.
was deposited.
But-
My case, amount was never deposited. Assessment and then reassessment was done, Lordship. That is bit difference in the, in their case, but the, facts is almost same, Lordship.
Okay, what is the difference in the rates? Why the difference in the rates?
Lordship, difference is coming in particular item of the horticulture plant, Lordship. That is the cardamom, Lordship. That is fruiting and non-fruiting, Lordship. That they have, Lordship will see, Lordship.
Earlier fruiting was 2,000.
2,000 rupees, Lordship.
Non-fruiting?
Non-fruiting, it was 1,000, Lordship. 1,000, Lordship.
1,000.
1,000.
And in the.
In the
Yes.
reassessed report, Lordship, assessment, they have drastically reduced just half of it, Lordship.
From where have they got these rates?
There is a notification.
There's one notification, my lord, dated 26/11/2000.
2011
Yes, madam.
notification. And this process of your. Now tell me one thing. In the earlier case also cardamom was involved
Lordship, yes.
and
Yes.
that rate was 2,000
Yes, yes.
and subsequently reduced to 1,000.
Reduced, Lordship.
But this court said it will be as of 2,000.
Earlier one, first assessed report. That will be considered, Lordship. The amount that was deposited, that was considered. That is the first assessed rate, Lordship.
Yes, madam. If that is the position, how can we now go beyond the division bench order?
That's true, my lord, but according to our affidavit, my lord. which
That was
come-
considered in that decision. 2011 notification was considered.
Yes, my lord, but here, my lord, in the Anjar district, my lord, in this stretch of land, my lord, the rate of the large contaminant was never notified, my lord. That's why it was deducted.
So you will have to take the rate which is there in the adjoining district.
That's true, my lord, but the stretch.
Your affidavit is filed
No, my
ready
lord, I'm going to file, my lord.
today.
No, my lord, within 2-3 days, my lord, because swearing portion is left, my lord.
File it on Monday.
Monday,
Monday?
Tuesday, my lord.
Tuesday. We'll have it on Wednesday. Good. List this, heard the parties at length. List this matter again on Wednesday for further hearing. We'll have to follow the division bench. If you have anything, you bring on record.
Yes.
Let us get it, otherwise that will be a point for appeal. Yes, Mr. Arun.
We have filed our affidavit, my lord, affidavits. There are two contradictory affidavits by the,
Tourism and the PWD.
yes, my lord.
Now, that's why you are here. As the additional advocate general, now you will have to resolve the issue.
Yes, my lord. Here, my lord, therefore, what I pray, my lord, some time may be given, my lord.
Now, what percentage of work did you do?
When I filed this petition, there's a 50%.
50% within 10 days, 15 1 month, 50% over.
No, my lord, not within 1 month, my lord. When I filed this petition, my lord.
23. Tenders was, agreement was with you on a particular date,
My lord.
but proximate there to the withdrawal was also there.
No, that was not intimated to me, my lord. Now the executing agency, that was never intimated to me, my lord. Neither till today, my lord. This
So
letter, my
there are
lord.
certain disputed things. Why don't you approach the civil court for damages?
There is no disputed fact in this case, my lord.
There is.
No, my lord.
Because the earlier decision is only 50 lakhs.
No, my lord. That
You
epidemic.
may not know.
No, my lord.
It may be somebody in the department, the executive engineer, might have gone overboard and done the things, but the decision of the tourism department is 50 lakhs.
No, my lord, that affidavit, that
No,
tourism
no.
department is continued to record, my lord.
Annexure 3 of your writ petition,
Yes, my report I have placed, my lord.
50 lakhs.
No, my 50 lakhs from my lord, 500, my lord.
Against this so and so, so and so.
50 lakhs from 500, my lord, 500, for exchange cost of 500, my lord. They pass, my lord. Now,
Mr. Ratan, resolve this issue, come back.
Yes, my lord.
Hmm?
Annexure 3 is initially
Initially
50 lakhs only.
no, my lord.
Initially 50 lakhs, subsequently 500. And what was the technical sanction given for?
My lord,
Amount?
we'll see this is the administrative
Administrative approval was given for
for 50 lakhs, my lord.
50 lakhs. Where?
Annexure 3 itself. This is
My lord, that is any submission contrary report, my lord. That's why, my lord will kindly pay this page number 68,
It
my
is
lord.
the administrative approval and expenditure sanction, my lord, not exceeding 50 lakhs, my lord.
My lord will kindly pay this page number 68, my lord.
Hmm.
This is the report of how this file was initiated, my lord. My lord will see at the top, my lord, BE 2023 500, my lord. Now that was processed to shift the Honorable One Finance and Honorable Tourism Minister, my lord.
Okay,
Now-
these were produced.
My lord,
This was processed.
process, my lord.
Then the final thing came for only 50 lakhs.
No, no, my lord. In my lord will kindly see at
Page 70.
page 70, my lord. Estimate cost of 500, my lord.
I got it. Obtaining FD's concurrence for an amount of 50 lakh only against the total project cost of 500. Right?
Today, my lord, my humble submission would be, my lord will give me just 10 minutes, my lord. I will try to impress, my lord. This, my lord, act of the authority, my lord, is not only arbitrary, my lord, but incompetent, my lord. This is malic in law, my lord. My lord will give me just 5 minutes, my lord. I indicate, my lord, the tender, my lord, was fall in the name of governor, my lord. This, my lord, action, my lord, was placed before the legislature, my lord, in the budget, my lord. This was the by action of legislature, my
Some
lord.
MLA came in and said,
No,
I only
no,
fed
my lord.
50
That
lakhs.
is the extent of dear, that epidemic, my lord, by the
Tourism
tourism
department.
department is
It's in your
continued
favor.
to record, my lord, for that they will be liable to perjury, my lord. My lord will give me 10 minutes, my lord. I
Yes,
try to
Mr.
impress, my
Ratan.
lord.
You have issued a tender. What is happening in your house, inside your house, how will he know?
Yes, my lord. That's
You have
why-
not even taken action against the executive engineer for issuing such tenders.
Exactly, that's why, since the affidavits, whether
Contradictory.
contradictory.
He has made out.
Not only contrary, but this epidemic is contrary to record, my lord, of the concerned officer, my lord, is liable to be punished under perjury, my lord. I also, my lord, just give me 10 minutes.
No,
my
no,
lord.
wait. No rush. Mr. Ratan is in a soup, let him come out of that.
No, my lord.
Yes.
Any submission, my lord, my humble,
Because he as an advocate general now has two hands in two departments.
yes, my
Both are saying contradictory.
Now, my humble submission, my lord, apart from that, he has a duty toward the court also, my lord.
Yes,
He should be fair, my
that
lord.
is why he is seeking some time,
No, my lord.
to be fair to me.
No, my lord. This, any submission or contrary record by additional advocate general, my lord, would not be my
See,
humble.
Mr. Counsel, there are two departments here. You are concerned saying about tourism department.
I will indicate, my lord, from the record, my lord, from the writ petition, my lord, the epidemic by the respondent, tourism, my lord, is contrary to the record, my lord. This is the, I have obtained through this RTML. This is a matter of record, the dear official record only, my lord. Therefore, my lord, my humble submission.
Yes, Mr. Ratan, when? Monday,
lord,
not Monday, Wednesday or Thursday?
My lord, since I'll have to speak to both the.
No, my lord, this submission, my lord, since
At least
many more, my lord.
I'll have.
We'll have it on Thursday. You get your house clear.
Obviously.
As prayed for by Mr. N. Ratan, learned additional Advocate General, State of Arunachal Pradesh. 2. As prayed for by Mr. So-and-so, learned Additional Advocate General, appearing for the state respondents, lists this matter again on Thursday, date 30. So Mr. Ratan on the next date shall apprise this court as to why contradictory stands have been taken in the matter by the two departments involved in the execution of the work carried out by the petitioner here. Obliged.
My lord, yeah, yesterday, my lord, my client has entered an agreements with the complainants, my lord, and instruct me to withdraw this petition, my lord.
Lord,
He is very influential. His appearance, you are gone now.
Yes, sir.
no, my lord,
I'm not.
I'm appearing for respondent number 3, my lord.
Three. Okay, fine. Where the council does not want to continue, why should we? At the learning council for the petition,
My lord, this may be put on record since I have been authorized by official respondent number 3. I have filed Bakalat Nama as well. This
No,
morning.
we'll record your name.
Well-
He's not proceeding, you now proceed against him legally. He's withdrawing the petition, what more is required? The learned council for the petitioner on instruction submits that the petitioner desires not to press the matter any further. And accordingly, he prays that he be permitted to withdraw the present writ petition. The said prayer is not objected to by the learned council for the petition, for the respondents. Full stop. Accordingly, the writ petition stands dismissed on withdrawal. Interim order passed by this court by order dated 22/12/2023.
My lord, may kindly reflect my name as because
Your name is reflected. So, what name lo
Obliged.
highly obliged.
May your lordship.
I can do one thing for you.
Lordship.
Give you 3,000 rupees back.
Lordship.
That'll do.
Lordship. Pardon.
You are paying compensation, you are paying maintenance of 10,000 and 15,000.
Yes, your lordship.
There is an order of the trial court that the compensation to your
Maintenance amounts.
second wife, I can't call her,
Lordship.
to the person who has landed you in the soup is only 7,000. But they are deducting 10,000.
Lordship.
So we will ask them to refund the 3,000 rupees to you.
Lordship,
Otherwise, there is nothing here.
may your lordship. Because lordship, if your lordship may see the findings of the inquiry officer, your lordship. In entire,
You have, why should I go into the findings when you have yourself admitted to that? You have not denied the parenthood of that child.
lordship, no.
Then, that means you are not married her. You have not taken permission.
Your
And
lordship,
being a police officer, such conduct naturally is a misconduct.
lordship. But the proportion, the penalty which has been imposed, your lordship.
Is 4 increments only. I have dismissed the matter in Guwahati High Court wherein it was removed. Sorry, before the wrong court, can't help it. Only thing I can do for you is a refund. Why are you deducting 10,000 when the order is only 7,000?
That,
Hmm?
maybe
Yes,
it's
you make
interim,
submissions, madam.
interim order.
Lordship,
This is the mind of the court you have to change now.
your lordship.
Now, right.
Lordship, memorandum of article was served on 7/12.
First question, any deprivation in the inquiry?
No. as per
Nothing,
procedure-
inquiry is
process,
perfect.
Lordship.
Very good.
Lordship. So my argument would be, your lordship. First point, your lordship, disciplinary authority has misconceived of my personal appearance relationship, your lordship. And
He
no
may have.
offense was committed, your lordship.
Madam, he may have, but you have admitted to that.
Yes, your lordship. I have admitted that she was aware of my first marriage.
That's
not
again
that-
a question of dispute. When it comes within the fold of preponderance of probability, your admission to that effect that you had a relationship is enough.
Your lordship, but there's a various judgment of the high courts wherein, your lordship, sorry, your lordship, today I'm not
2 o'clock. Others I'll forget. 2 o'clock. I'll give you back 3,000. That is an assurance from this court.
Interim was for 10,000, final was for 7,000.
7,000. I'll give you back 3,000. Otherwise, you convince me why this order is bad.
So your lordship.
Because say, madam, this court will come in when there is some fault or default in the conduct of the inquiry. There is none. As to whether the charge, what would be the penalty if it shocks me, I would surely come. But 4 increments does not shock with the amount, with the conduct, with the conduct you have, because you have basically betrayed or they lost the trust of 2 ladies.
Lordship.
And she's admitting that the child is his.
Child is yours. You have not
There is
denied
no
that.
dispute in that.
You have not denied that.
In
You have
my,
not denied even the relationship.
in my petition, your lordship, I have made one statement, your lordship. In our traditions, in our customary,
But that has been dealt with by the respondent authorities saying that you have not married her. If you had married her, it would have been a different question
for
altogether.
that also, your lordship, we don't have any.
You are a servant, government servant. You are
Lordship.
bound by the conduct rules.
If he marries, he will
You are
be
bound
again.
by the
But
conduct rules.
In the affidavit which they have annexed with the,
Affidavit. Fine.
your lordship. In the affidavit, they have annexed one guidelines, your lordship.
That is general.
Your
That is attached to a government servant moment he enters the service. That
It
you will
says-
not marry
Yes.
during the existence of your spouse without permission.
Without-
And if it's your tradition that you can marry, you can apply, they'll give you a permission.
Yes.
But here, you went to the extent of denying first any relationship. But when it came out, you accepted.
No, I'm not denying your lordship.
That is great.
I'm not denying your lordship.
Anyway.
Uh,
You start, only thing is you're paying them, pay them.
Maintenance, I'm paying your lordship,
Pay.
but since I have my old aged parents also, which I have to look after, your lordship.
That you
And
must
after
have,
paying the,
that you should have thought before you committed
after,
a misconduct.
after deduction of all the maintenance amount,
Get around 12,000 rupees.
lordship.
Can't help it.
So it
Maybe
has,
by the 7 CPC, your pay has also increased a bit.
your lordship.
The matter of 2024. Okay, I'll give you a chance, Tuesday,
Tuesday, lordship.
but show me judgments, others,
Lordship,
you
I'll
have,
come up with
I have
judgments, your
disclosed my mind now.
Lordship.
Only the order I have to dictate.
Obliged.
Tuesday. Heard the councils for parties at length, list this matter again on Tuesday. We'll give her an opportunity.
Yes.
3,000 you are getting back. That much I can assure you.
Obliged.
Mr. Ratan will make the necessary calculations for recovery of that excess pay. Yes,
Lordship, Lordship, it was fixed for reply by the respondents.
on the prayer made on behalf of Mr. M. Tatu, Learned Council for the, right?
Yes.
Learned Council, done a DY SGI, who is stated to be out of station today. Also raised it to list these matters again after 3 weeks. In the meanwhile, the respondents shall invariably bring their stand on record by way of filing affidavits in the matter.
Lordship, there is an interim order that may.
Interim order passed earlier to continue until further orders.
Much obliged.
Hello.
Yes,
My lord, I am deeply obliged for giving me some time so that I could go through other related my cases, my lord. My lord,
oh, now tell me, have you scrapped that? Have you scrapped that tender process?
not
In
yet,
terms of paragraph 16 of
My
your
lord.
affidavit.
not yet, my lord. Then beside that, my lord. There are 4 related cases of betting, my lord.
Here,
Yes, my lord. Out of that, 3 belongs to my friend, my lord. And in another 2 cases, private respondents are there. They have already filed a IA for vacating the interim order. The entire matter is fixed on Monday, coming Monday, that is 22nd, my lord. my lord. In another case, even he is also private respondent, my lord. The issue is same, my lord, challenging the, my lord, annexure B
That is-
5 and 8, my lord.
That is the beauty of Mr. Doctor.
My
He can
lord.
handle both
So
sides.
that's why, my lord, everything he give me, my lord, surprise, my lord.
He
So-
can handle both sides.
So I just reminded him, my lord. So, my lord, may I suggest, my lord, let entire matter be fixed on
So
Monday.
in the other two writ petitions wherein
Three.
Mr. Dotto
Yes.
is the private respondent.
Yes.
They
No, no.
challenge.
In one of the writ petition, he's a respondent, my
Okay,
lord.
in that
And
writ-
another writ petition, he's a petitioner, my lord.
and in that writ petition, is there a challenge to the calculation method?
Same, my lord, annexure B, clause 5 and 8, same, man, same, nothing
Give me the
different.
numbers.
My
My
lord, my lord, my lord, my lord, before he.
Now, I can give
Takes
the
it
brief
all
also, my lord, we should.
No, no, I'll not hide
Mr.
anything.
Dotto is not there.
I'll
Yes,
not
Mr.
hide anything, my lord. Just as I said on 16th, my lord. The other three matters are in respect of a tender which is different from this one.
Item may be different, my lord, but
The
issue
item
is same.
No, just
Items are different.
items are different, value is also different. Here, the value of the tender is 5 crores. There, the value of the tender is 10 crores.
How, what is the starting up to 20 is here, there?
Their melody is in a similar way, but there they have what they have done. As I said on the earlier date,
I remember.
they have issued a corrigendum in respect of that tender.
Hmm.
Thereby, well, I'll just show that.
What is that corrigendum?
Now, in the corrigendum, what they have done, the other day I have shown to your lordship in this case that clause 21L and the clause 4 in the annexure B are in apparent contradiction. They have tried to remove this apparent contradiction so far as the other tender is concerned. How? This is the corrigendum. Your lordship will kindly have. I don't have a copy.
No need.
Subsequently. Now your lordship will see clause 21L on the top of it. This they have modified, and also they have modified the clause 5. Sorry, clause 8.
Clause 8, not body.
Clause 8. So these changes are not there in the present case. So the factually also, my lord, the present case is different from the other set of cases.
No.
Yes.
No. Clause 8 is not modified.
The net worth
Now
of a
maybe read
tender shall
Read
be
H
as
clause 8.
indicated in serial number
What was
8
the
of the
letter B
qualification
indicated
points
in
at
serial number
annexure B.
Qualified point 8.
So qualification point 8, net worth of the bidder should be
Is, my lord, up to 20 crores,
up to 20 crores.
you'll get 5 points.
So they have amended 21L and made it in connoissance with
Yes.
clause
my lord.
8.
Yes.
Clause 8. Then serial number 4 at annexure B. Average annual turnover 10 crores in each financial year for
It was average. Now they have made it
annual.
Single year.
Now they have made it annual.
Okay.
That's
No, forget those cases. When it comes up, we will treat. Now, let's.
These changes have not been done.
No need, forget it. Now,
Now, my lord.
Mr.
My lord.
Now, forget the earlier cases. Forget it. Now, you have in paragraph 16 said that none have been found to be eligible, so everything's scrapped. So can we take it that the tender process is scrapped?
My lord, we have filed in our affidavit, that is the contingency.
So, no. This is there, para 16, but the orders are not here.
No.
No, my lord.
The orders cancelling that process is not here.
Not there, but recommendation is there by the tender committee.
So has this recommendation been accepted?
My lord, that
That is what I wanted from you.
No.
No, my lord, that
has not been accepted, my lord.
So if it is not been accepted, how can we say that the tender process is scrapped? The authority may again
My lord,
rethink.
as we have said, my lord, not a single bidder that succeeded.
I know that.
So maybe, is
then
there any
that may-
alternative, my lord, instead of scraping or going for the fresh?
No. But there are instances when the recommendation by the tender committee has not been accepted by the employer and a different mode has been
No, my,
prescribed.
no one, my lord, qualified as per the terms and conditions.
Nobody got 90.
Yes.
So
So if we violate that, my lord, that will bearing in the other cases. my
Mr.
lord.
Navam, you just make a statement before this court that this tender process, you are scrapping, you are not proceeding with this tender process. Then I will close this writ petition, give him a liberty
My lord.
to approach the government by way of filing a representation highlighting the contradictions in the tender condition, and the government will consider that before issuing the fresh tender.
So can it be taken up with two?
Why delay him?
Yes,
Little before that. Whereby too, Mr. Doctor may have fixed his lunch somewhere.
But only I'm worried. Any other pass in this matter, definitely the bearing will be not.
I'm not on that.
Yeah.
I'm not even, I will not even issue a mandamus. I'll only say the this repetition, we cannot decide because this matter has been scrapped.
Scrap, my lord.
So, but the petitioner's issue will remain. So I give him the liberty to file a writ petition, file a representation, highlighting the inconsistencies. You will consider that and thereafter dispose it off and thereafter proceed with the tender process.
Yeah, fair enough, my lord. It's a fair, but otherwise also, my lord, I'm just trying to extinguish his doubt, my lord. Even if your lordship would issue a mandamus in the case, assuming, my lord, for a moment, saying that these are the inconsistencies for which, my lord, this cannot be gone into, that will not have any bearing on the subsequent tender, because for the reason that in the subsequent tender, my lord, they have issued a corrigendum, and we have also challenged the corrigendum. That's why, my lord, the number of cases are more. And in the corrigendum also, my lord, there are certain inconsistencies. So in any case, my lord, even if your lordship issues a mandamus or issues some observation saying that these are the apparent contradictions, my lord, the contradictions are plainly evident.
Now, Mr. Doctor, Mr. Doctor, if the tender is scrapped, this court is not going to enter into the.
No, that is understandable.
We will not prejudice their
No,
rights.
that is understandable. But my lord, my instructions are that day before yesterday only I spoke to the petition counsel. No, the petition counsel.
I thought beforehand.
There is no official communication of this.
That Mr. Nawam will get it
I'll take the instruction.
within 1 hour. Before first hour.
My lord, my friend is, my lord, time and again asking for the mandamus. When the issue does not survive, my lord.
I am just saying, my lord, assuming for a moment.
Mr. Nawam, why are you having worried? Mr. Doctor is just trying to clarify. Assuage your apprehension, if any.
Yes.
My
I'm
lord,
just trying to clarify.
because what I have found it, my lord, entire other petition, they have challenged the, my lord, column 5 and 8, which carry the same thing, my lord.
No, we will have it after some time. If that is the stand, we will, if you have scrapped it, make a statement, we will record that, and then we will give him a liberty. That's all.
My lord. 2 p.m., my lord. Or,
Mr. Doctor?
my lord, you can have a good lunch. Don't worry.
that he'll sponsor, my lord.
No,
he'll sponsor.
If sponsor in 5-star also, he'll not be interested. He has some other
business, my lord. He's a big man.
some 2 hours distance from here.
Well, no, that has fallen for your lordship only, my lord. I simply remember the address.
Okay.
The delicacies are really mouth-watering.
Whenever you get it, just tell him.
My lord.
Yes, Mr. Dury.
Yeah, I had just received the affidavit in opposition. I need some time to file rejoinder.
Why? This was filed long back. Filed on 17th. How did you receive it today? Now forget the affidavit. We are not worried with the affidavit. Now tell me, if this is forest land, how can you be there?
You're under
That scheduled tribe, scheduled caste, scheduled tribe, Forest Dwellers Act or rules, 3 generations should be there before you can be settled a land in a forest.
Yes.
Right? You have yourself said that you are there from 1970 or 72.
But before the notifications came.
But once the notification comes, you're gone.
Now, Your Honor, one more thing is there in Annexure 1.
Where is that? Wait, I'll show you. That act is. Where is this Arunachal Pradesh forest ejectment of unauthorized? I think that you have brought on record.
This is 2013.
There is another act, what is it called? Scheduled Tribes and Other Traditional Forest Dwellers, Recognition of Forest Rights Act 2006. Huh?
This is barrack. This may hold on.
Barrack. Scheduled Tribes and Other Traditional Forest Dwellers. It should have like. Therein you require 3 generations.
We have more than 3 generation there.
You say you came in only in 71.
No, that was settlement from Kangham area. That was a government settlement. We have been resettled there.
Be that as it may.
And one more thing is there. They
When was this forest notified?
1983.
82.
83 years. 82, but it was notified only in 1983.
83 it was notified.
29th November 1982, sorry.
Yes, Mr. Ratan, what do you say? Hmm.
Only after exercising all these, at that point of time, when the notification was issued, and any right, their rights have been recognized at that point of time. Now, having said, yes, saying that we have been settled there. That procedure, it's an entire procedure, any right?
Your Lordship, moreover, they are issuing eviction notice.
No, there is a procedure for notification, that there is no doubt.
Whosoever has any right, their rights are in the notification itself, the person has rights, names are
Now, one more.
Now show me, what is the document to show that you are there from 1970?
Your Honor, one more thing is that
No, no,
this
what is the document?
documents I have actually like that survey cadastral report.
Huh?
Survey cadastral report.
Where?
That is in page number 30, 29 onwards.
Page 30?
Page 30 of my read petition. It was prepared in 1970.
Who has prepared this?
This was prepared by the Mandal.
Huh? When?
Here it's written 1979. Chumpoy Kagam, Moja Kagam Dayun, District of Arunachal Pradesh. And more.
You have land documents with regard to this?
Land documents,
Then-
this is the SITA register wherein my name is mentioned.
Then
Yes,
if
record.
your name is in the SITA, then you must be having, this is Arunachal.
Arunachal.
You must be having a land possession certificate or something.
No,
like that.
no. In the earlier time, only SITA register they used to maintain. This is the SITA register. On top of that, they had issued eviction notice after this was, diversion was made. Now it is no more forest land, Your Honor. As on date, eviction notice is illegal. They had already diverted that land.
Where?
It's in page number 16, Your Honor, Annexure 1. Very first line. The government of Arunachal has renewed and approved diversion of 7.11 hectares of forest land for oil drilling locations, KUP, and in village of Sumpoi 2.
Yes, Mr. Ratan.
It is no more a forest land now.
Because whether approval has been taken, my lord, for diversion.
Has renewed and approved diversion of so and so.
Yes, ma'am.
Joint survey. So if that land he is sitting, then if you are acquiring, you will acquire the land.
Yes, my lord, for. if-
What we do is, we ask him to approach the deputy commissioner. Because now now, if the land is already diverted. How can the forest issue this notice?
Eviction notice, that is illegal.
Forest cannot.
Yes, my lord, this.
Have you made any statement?
No, he had not made any statement.
Therefore, my lord, what I'm proposing, my lord, whether diversion has been approved, my lord.
Well, that's the government of Assam, Arunachal Pradesh has approved diversion. That's the
Yes, that is the
opening
letter
words.
from
And
government of
that is by
Arunachal
the
Pradesh.
deputy commissioner. If it is a forest land, he would have no role there.
My lord, will file affidavit on behalf of the
No need.
respondent.
You have
wife,
your instruction. Just have your instruction.
Deputy Commissioner.
Mr. S.K. Deori,
D.K. Deori.
D.K. Deori, learned counsel for the petitioner, and also Mr. R. N. Ratan, learned additional advocate general appearing for the state respondents. Mr. Deori has at the outset submitted that the process of eviction as carried out in the process that the notice for eviction as issued in the matter by the Divisional Forest Officer, Nangpung Forest Division, Jairampur, is clearly without jurisdiction inasmuch as such notices were so issued after the government has renewed and approved a diversion of 7.11 hectares of forest land for oil drilling location, KUP and KUL in village Sompoi 2 and Mudaka Nala. Full stop. Mr. N. Ratan, learned additional advocate general, however, submits that he would have to receive instructions in the matter on the issue now raised by the petitioners, learned counsel for the petitioner. Accordingly, raised it to list this matter again on Wednesday.
Let the status quo order be continue.
Huh?
Status quo order.
Status quo order passed.
Here, Your Honor, there are another 11 connected matters, same issues.
Same issue.
All that be listed together.
You give them
All
this.
together. From WPC 133 to
No, no, give
WPC
it to him. Item number
15, 16, 17.
15, 16, 17, same. Ek order mark. One order.
One order, then rest 9 can be
9
clubbed together.
matters together you can do. And if that land is already diverted, it is with the deputy commissioner.
Deputy
now.
Commissioner.
So this whole process is gone. Then you do it as per law.
Yeah.
Wednesday. Yes. Yes.
Yes, my lord, I need some more time as I need some instruction, final instruction from the petitioner client as
Final instruction,
whether to
documentary, oral, or MI?
oral.
Oral, then no action. You have filed your wakalatnama?
Yes, my name is there.
Yes, yes, concept.
Your Honor, I'm appearing on behalf of M. Kato, DSGI. We have filed our affidavit in regard to this.
This matter came up
Yes.
Monday or?
Yes.
Yes.
Already matter has been heard, Your Honor. Only the passing.
Endeavor was made to whether to this withdraw or dispose, but I need some final instruction as I could not contact the client.
Okay, that's why we said that go before the
Yes.
lower court.
Yes.
Then,
Civil
and what is the stage of that work?
Yes, Your Honor.
Execution of the work, retender work. What is the stage? Completed.
Yes.
Mr. Kato, I think, has said it was complete.
Yes, 90%, 80 to 90%.
90% has been
Yes.
complete. So why are you here? You go before the lower court, claim damages.
For that, I need final whether to withdraw it.
Why carry these matters? Slow.
Hello.
Get your instructions. Slow.
May I please, Lordship? Lordship, this morning I have prayed for the for adjournment, Lordship, as the leading counsel.
You have.
Out of
to
station,
proceed.
Lordship.
You have filed your affidavit, Mr. Kamal.
Yes, my lord.
What is your stand?
My lord, the stand given by the department, my lord, I don't find much logical, my lord. Fair, I don't find fair. Frankly, my honestly speaking.
Please, you are an officer.
My
of
lord,
the court first.
It says that because of the pressure exerted by some organization, the cancel has been done, my lord. I don't find fair on my part, my lord.
And they are continuing. You are continuing in your
Yes,
service?
Lordship, we are continuing, sir.
Okay,
Lordship-
take me through that. Where is your initial appointment order, so candidates on contract basis under so-and-so? Where is your name here? Page 35. Madhubiam. Okay. Then what happened? Madhubiam released. Block account officer. Okay. District data manager.
And the appointments done based on advertisement at page 42.
Advertisement and also your departmental promotion. committee.
Yes, my lord. Advertisement 42 and page 46 appointment.
The re-advertisement has been stayed by this court.
My lord.
What happened to the re-advertisement?
My lord, no further process, my lord. And these, the petitioner, they are continuing, man. And their
Only
service.
one petitioner?
My lord,
Only one petition?
Two, Lordship.
In this
But
petition, there are two.
Lordship in different posts, Lordship.
What is the other?
Connected.
Connected, Lordship.
Where? Item number?
Item number 19 and 20.
19 and
20. Okay.
90.
Both are district.
Yes, same.
Okay. You're working now?
Yes, Lordship.
Societal interest is always greater than personal interest.
My lord.
Lordship, recent extension order is also there, Lordship. Recent extension order is also there, Lordship.
Oh.
No, no.
You are appearing.
Yes. But I am a performer, I cannot make much of the.
Who are you?
Complainant.
In item.
Will interfere with the cancellation insofar as the petitioners are concerned.
My lord.
Right? And continue them in terms of your scheme, because there is no material brought on record that there was any deficiency in their consideration. What more?
Only the issue is because of the pressure, but that cannot be ground, man. That is, yeah.
खत्म करके order दे देगा।
That's fair.
But then, well, only one consideration is there. Once the initial it is for the contract.
Contract, they are extending it from time to time.
The contract only.
Time to time. Now the question comes, can it be regularized by holding a DPC?
No, it's not a case.
No, it's not a case of regularization. It's a case in NHM. Any appointment or any, this is actually, he was in a lower post.
Yes.
He
higher
applied
post.
for a higher post. Therein, they call it a departmental promotion. That's the body they have constituted under the NHM guidelines. So that body has considered and given him what more.
That is, under duress, everything has been done.
No,
that's.
That one has to be
And they have, the department is categorical enough to say that we have done it only because of this pressure.
That's it.
We'll pass the order after finishing the list.
Deeply.
We're supposed to take order pass करेंगे।
May I please, Your Lordship? This is the case, Lordship. In my writ petitions, Lordship, I have mentioned, Your Lordship, in my para 5, Lordship. Well, going the
Have you brought your readings on record?
Yes, Lordship.
5 and 6 have filed.
That's fine. We also
This
want-
firing range is under the state government or the central government? It's a army firing range.
Army.
Yes.
And
Yes.
Where is your affidavit?
Yes, already I have filed my affidavit.
Your file.
Yes, sir.
So ready for consideration.
Consideration already, as per the notification of the Deputy Commissioner, we have already notified before the district administration, stating that the firing will be held on specific date. That is annexure 1. volume. Wide circulation has already been circulated.
Okay.
Well,
No more further pleadings to be brought on record? Madam, any further pleadings?
Other this Your Lordship, as per the pipeline 6, in their annexures.
No.
Rejoinder
Is there any pleadings to be brought on record?
Rejoinder we have.
Then you have to file.
Yeah.
As prayed for by the learned counsel for the parties, petitioner lists this matter after 2 weeks. In the meanwhile, the petitioner is at liberty to bring on record bring on record the rejoinder affidavit on behalf of the petitioner against the affidavits filed by the respondents here.
Oblige, Your Lordship.
Yes, madam.
Your Lordship, I may.
Respond number 4. Not yet taken steps.
Respondent number 5, Your Lordship.
Who is respond number 4?
Tok Tamang, private
Why
respondent.
have you not taken steps?
Your Lordship, because
earlier also I have taken this step and it was not served. Later on, it's come to my knowledge that the respondent, private respondent is in jail. So I may be allowed to take the dusty. Your Lordship.
Dusty,
Yes,
both 4 and 5.
yes. 4 is completed.
4 is not completed. Service report in respect of 4 is awaited. Steps were issued on 2/3/24. Right?
Yes.
The learned counsel for the petitioner submits that she be permitted to take steps, fresh steps upon respond number 4 and 5 by way of dusty mode, routed through the, by way of dusty mode, full stop. Prayer accepted. Petitioner is permitted to take steps for service of notice upon respond number 4 and 5 by way of dusty mode, routed through the registry of this code. Full stop. On the service of notice being effected, the petitioner shall file an affidavit to that effect before disco. In the
I'm appearing for 1 and 2.
Ms. So-and-so appears for Sangeeta, appears for respond number 1 and 2. Respond numbers 1 and 2. You have filed your affidavit? Yes.
Oh, bless you.
List after 4 weeks.
May I Lordship, Lordship here, service upon respondent number 4 is still awaited. I may be allowed to take fresh step now. So,
In the office note dated 18/7/2024. So, service upon respond number 4 is not complete. The learned counsel for the petitioner submits that he be permitted to take fresh steps for service of notice upon the respond number 4. Prayer accepted. Petitioner to take steps for service of notice upon respond number 4 within petitioner to take steps for service of to take steps for issuance of fresh notice upon the respond number 4 steps within 3 working days from today. Registry to list this matter again after 4 weeks.
obliged, Lordship.
My Lordship. 26. Lordship, kindly see the page number 32.
No, your steps are not complete. Respond number 6 is.
Lordship, we have already settled, internally we have settled the matter that.
Then you withdraw this.
With regard to that the community land, that is one of the allegation.
You withdraw it if you have settled.
No, not.
Then you take steps upon respond number 6.
Lordship, can we, Lordship, kindly see page number 32. Herein, we are not burdening on that private respondent. We are saying that Deputy Commissioner has already passed an order for re-verification of the project affected family. But very little time was given. It was from 29 September 2023 onwards. This order has been issued on the basis of our representation. But no sufficient time was given.
So you don't want respond number 6 here?
No.
Delete him.
Yes.
Mr. So-and-so, learned counsel for the petitioner submits that the name of the respond number 6 be deleted from the array of respondents. The same is not objected to by the learned, Madam Amdina, not objected to by the learned counsel, learned government advocate appearing for the state respondents. Full stop. Accordingly, the name of the respondent number 6 stands deleted from the array of respondents. Full stop. Petitioner to file an amended cost title within
We
3
will be
working days.
allowed to write.
Amended cost title. Only the cost title. Amended cost title within a period of 3 working days from today. Full stop. Ms. So-and-so, learned counsel appearing for the state respondent submits that she be given further 2 weeks 2 weeks time to bring on record the stand of the respondents, state respondents by way of filing an affidavit in the matter. The registry to list this matter after 2 weeks on a date 2 weeks later.
In this matter, the leading counsel, he asked, called me up today morning to take adjournment. He's not personally well. Mantau, CW Mantau.
What happened to him?
I think he's not well.
He's not well.
Suffering with
Lordship,
virus.
no extra copies has been served to us till now, your lordship.
Man is not well, whom will I tell him?
Because
Learned Counsel, it is submitted on behalf of Mr. C.W. Mantau, Learned Counsel appearing for the petition that he is presently indisposed and accordingly not in a position to appear before this court. The accordingly registry to list this matter again after 2 weeks on a date to be fixed by Ms. So-and-so, Learned Counsel appearing for the state respondent submits that the extra copies of the writ petition has not been furnished to her. Learned Counsel for the petitioner shall ensure that the extra copies be furnished to the Learned Counsel appearing for the state respondents within 3 working days from today.
And yes, status quo order is there. Letter.
Interim order passed, if any, shall continue till the next date of this.
Obliged.
None is appearing for the petitioner.
Yes, my lord, since there is no interim order, there is
That
no
has been-
protection because
We'll
maybe,
dismiss it for default.
my lord.
So this 26 to 52. And otherwise, how can this matter be pending here? Their land, your case is that their land was not taken. If their land is taken
Even their land was there, that was beyond the ROW.
out of, so you have
Yes.
left it out, so no
Yes.
compensation. Now, if it is within ROW, they'll have to establish that this is within ROW. Can I go and look?
Another issue, my lord, since some of the petitioner, my lord, beyond ROW, my lord, even compensation they have received, my lord. So we have.
You have asked for recovery. of that.
Recovery, against that they have, for your
And there is
lordship.
no interim order. We'll dismiss it.
Well,
None appears for the petitioners on call. Ek order mana, 28 to 52. None appears for the petitioners call. Mr. Nawab, Learned Additional Advocate General, assisted by Ms. P. Pangu, Learned Government Advocate appearing for the state respondents are present. So, in view of the above position, this writ petition stands dismissed for non-prosecution. Yeah, okay. Yes, we have got the instruction.
my lord, yes, my lord. Now, my lord, the filing before the office minister, my lord. So I asked the joint secretary to have a copy to the minister. My lord, they said, my lord, it's 110 days they are doing this.
But why should we put it that in your mouth? Let it come from them through you. We'll have it on. You come online, no problem. Tuesday.
Actually, from next Monday, I'll be out of state also.
That's
I'll
what
be,
you will be, your message to 22nd.
no, there will be some different accommodation. I'll have to take my son to for his admission. For the next.
Now you tell me one thing. If they come and tell us that this is the way they are going to do it, that they have scrapped the tender,
So if the tender is scrapped, my lord,
then I will permit you, say, give you 10 days time to submit a representation highlighting all this. And thereafter 15 days, they will dispose. And then only they will proceed for further tender in this matter. That'll do?
Yes.
Then you need not be here. We will record your name that we are passing this order.
But if your lordship is passing that order on some other day, my lord, then perhaps some.
Because I don't want to trouble Mr. Nawab. Because if he does not have that exact instruction, we'll not presume. No, we will not. Okay, we'll have it. I heard the Learned Counsel for the parties at length. I heard the Learned Counsel for the parties. Mr. Nawab submits. Mr. Nawab, naam likh ke, Mr. S. Dutta, assisted by so-and-so. Mr. Nawab, assisted by so-and-so. Mr. Nawab submits that he be granted a week's time. 2 weeks time. When are you coming back?
So 29th it can be kept, if your lordship is taking.
29th is what?
Or 20, there is possibility that I will be back on 25th, but to be safe on 29th. Or 25th, if your lordship is here, my lord.
25th I am here, 26th I am.
Your lordship can keep it on 25th.
25th.
Or 24th.
6th, 26th.
26th,
Friday. You come online, Mr. Doctor.
26th.
Or there will be some variation of rates. Wow. Very auspicious.
Actually, my lord, he also knows. 21st, I am leaving out.
Oh, no, please, that's more important. That you should do. 26th will be comfortable?
We'll let it be 25th.
25th. Mr. Navam submits that he be granted a week's time to receive instruction as to whether the tender process involved in the present, the NIT involved in the present proceeding has been scrapped. Full stop. List this matter again for further hearing on 25/7/2024. अभी जो ऑर्डर देने के लिए फाइल रखा है जो 2-3 नहीं ये तो चला गया जो हम 2 बजे ऑर्डर देगा बोला था वो हमको एक किताब के साथ अंदर में दे दीजिए बाकी जो आएगा 2 बजे दे देगा ऑर्डर हाँ हाँ 2 है अब जो ऑर्डर दे के नहीं कि हम 2 बजे दे बोला था ना ये एक थे और एक टू मैटर है दोनों हमको अंदर में दे दीजिए इज कमिंग ऑन मंडे
Yes, Makka coming.
as prayed for on behalf of Mr. M. Kathu, learned counsel appearing for the petitioners, raised it to list this matter again on Wednesday. We'll dispose it upon that.
Yes. Hello.
Yes. What is your instruction?
So for the special distinction model, we have a particular length, but not exactly here. So but already that 622 feet is there, what has been given in the petition. Now, madam, there is a, that the structural matter, because so far they have not measured exactly what is there.
So you don't know what you learned.
Now, madam, now,
And what is your instruction, Mr.?
But
622 square feet, feet, he says.
but the instruction is the conduct of the respondent number 4 is not impeccable.
That model so far we have only measured in
Page?
page 46.
Of the writ petition. Hmm. Which one? Hmm. You purchased this. But this is just a map. Do one thing. You approach the civil court. We will provide for that.
But my argument would be, this should be disposed on the merit, what has been protected as part of protected living. My submission would be possible, there, what is the
Legal.
issue involved in this case is whether there is an existence of the Bango level kebab or not. I am ready to demonstrate and establish that there is a Bango level kebab. This brother, this morning actively said that the hierarchy of the kebab system is first village level.
No,
second,
Mr. Modi, that there is no dispute. After the 23 amendment, Bango level kebab has come in.
Then hereafter also, if reason, if reason
Okay.
conform with the.
Okay, we'll hear you. We'll hear you then. So you are not interested to go for the civil suit?
Well, the person who should go, that is to be decided. My submission is that if the.
No, you are the one who is claiming.
No, man. The party who should go is the petitioner. My submission.
Heard the learned counsel for the parties at, party counsel for the learned counsel for the parties. Post of hearing remains inconclusive. Registry to list this matter again on Tuesday. Wednesday, Thursday. Cut it. Heard the learned counsel for the, heard Mr. T.T. Tara, learned counsel for the petitioner, also heard Mr. Modi, C. Modi, learned counsel appearing for the private respond number 4, also heard Madam. Madam का नाम आगे लिखिएगा, respond number 1, 2 and 3. That is the state respondents and Mr. C. Modi. As prayed for by the learned counsel for the parties, list this matter again after 2 weeks on a date to be fixed by the registry.
Interim order to continue.
Interim orders passed earlier to continue. I wanted to give it a closure today because it will not take us anywhere. Merit, it will not take us anywhere. Anyway, fine.
Grateful.
Yes.
Yes, Lordship. Lordship, I'm having the second copy, Lordship. Actually, I had misplaced my file, but then Lordship, issue is very simple. I have the second copy, Lordship.
Now,
I can
see,
highlight some
that
facts.
date, only that date problem is there.
Lordship.
But the fact that they have filed an appeal is a fact.
Lordship, yes, now we have filed this perjury case, Lordship.
But have you seen the affidavit filed by them after that?
Lordship, page 78 of my application, where the Deputy Commissioner says that there is no appeal filed. Normally, appeal is filed before the Deputy Commissioner. I don't know where they
Something
have
has
filed
happened,
it.
but now the Deputy Commissioner has also, there is material to show that the appeal was actually filed. Right? Then what is left here? Perjury. Perjury is not something very simple. It has
Lordship,
to be something more than a mere suppression.
I understand that, Lordship. My contention would be, Lordship, since we have approached the Deputy Commissioner and this very order, page 78 was passed. So we had to presume that no appeal was filed. But later,
after the affidavit, what do you say? You have not filed a rejoinder to this?
no, we have not filed.
Then withdraw it, fight it out there. That is pending.
Pending also, inside also it is pending because after filing of this unit case, the matter has not been taken up.
So withdraw this, go and fight that thing out.
Lordship, this matter can be closed, Lordship.
You, if I have to close, I'll have to go on merits. Then I may have to go against you also. I'll have to go on merits. I'll have to adjudicate that perjury. If I don't find perjury, then that would be another complication for you.
Lordship, simply highlighting that.
I'll not highlight. I say that after arguing the matter at some length, the learned counsel now submits that the parties would now have the matter considered on merit before the Deputy Commissioner in the appeal pending before him. That's all.
That can be passed.
Heard the learned counsel for the petitioner. Also heard the learned counsel for the respondents. Respondent 1 to 36. Also, the learned counsel for the petitioner, after arguing the matter at some length, has submitted that he be permitted to withdraw the present interlocutory application, more particularly in view of the disclosures as made in the affidavit filed by the respondent number 1 to 36 herein, and with liberty to pursue the appeal presently stated to be pending disposal in the records of files of the Deputy Commissioner
Pasigat.
Deputy Commissioner East Siang at Pasigat. They said,
Lordship, in this matter, now since the Deputy Commissioner cannot take up the appeal, Lordship, may kindly direct the Deputy Commissioner to send it to the appropriate.
This is only an interlocutory application. How can I do?
Otherwise, sometimes what happens is
you go there, make a prayer. This is a proceeding, I can't add anything to that, then I'm limited here.
Lordship, I can understand. Just I wanted
What
to-
did we write last, madam? So the said prayer, or the said submission of the learned counsel for the petitioner is not opposed to by the learned counsel for the respondents. Also, in view of the above, the present interlocutory application stands dismissed on withdrawal. However, with liberty to the parties to proceed in the matter, with liberty to the parties to proceed in the matter in terms of the law holding the field.
It's in place of lordship, dismissed, can it be closed?
Closed.
Lordship. Otherwise, the clients, they
Closed.
sometime
Closed.
obliged.
19 and 20. ये तो डिस्पोज कर दीजिए, हम दे दिया, बोल दिया था और है कुछ ये हमको दे दीजिए.
Number 18 was there.
18.
Yes.
You got something here?
My lord, I may be allowed to withdraw with the liberty to file before appropriate court.
Mr.
B. Kamdak.
Me conduct learned counsel for the petitioner. Also heard Mr. M. Tana appearing on behalf of Mr. M. Kato, DYSGI. Also, the learned counsel for the petitioner after arguing the matter at some length has in view of the issues as arising in the present proceeding, has submitted that he be permitted to withdraw the present writ petition with liberty to approach the competent court of civil jurisdiction for redressal of his grievances. Also, the said prayer is not objected to by the learned counsel for the petition for the respondents. Also, in view of the above, the writ petition stands closed on withdrawal with liberty to the petitioner's hearing to approach the competent court of civil jurisdiction for having its grievances redressed. Full stop.
Deeply obliged.
Again, हमको फाइल